Vandana, you can begin.
Yes, everybody has joined? No.
Yes, yes.
Section 406, whereas criminal cases are to be transferred, will not be complete unless and until I will mention Zahira Habibullah Sheikh's case versus State of Gujarat, whereby, as you all are aware, that the Gujarat riots, it's pertaining to Gujarat riots, whereby Zahira Habibullah Sheikh was a complainant, and she moved to Supreme Court on the ground that she is afraid to get fair justice from the trial court in Gujarat.
मैम वॉइस चला गया
नहीं Vandana lost the contact. Wait for a minute. She will rejoin.
ओके मैम
Maybe.
ओके
Till Vandana comes, she had discussed. Vandana को phone लगाओ. WhatsApp टाक दिला Vandana. Till Vandana comes, she had discussed Shankari Prasad case. From there you have to begin. Always remember, Shankar Prasad is a very old case. खड़क सिंह का जो guidelines है. Has Vandana come back? Hi Vandana. टाकला ना वैसे. And there is Minerva Mills case. She has discussed Antule's case. Antule's case is very important because it was declared as a special case and he lost one right of appeal. तो उनका private right affect हुआ था as an accused. That is very. He was the CM of Maharashtra. So Antule's case, those who are appearing for the AOR exam, they should know it. काय झालं वंदनाचं? Tell her to join from a cell phone. Otherwise, cell phone में join कर सकते हो. Also, fundamental rights are very important when you appear for Supreme Court. So, Article 32 and 220, somebody asked the question, very valid question. So, when you appear for AOR examination, mostly 32 is सब लोग पढ़ते हैं, but 226, though it relates to High Court, we should know it. 226 also has to be read when you appear for AOR examination, because there is a question in one of the AOR examination, what is the difference between Article 32 and 226? ना लेना वंदना कर कॉल कर
Yeah, she has come.
Another important point, she spoke about the public interest litigation. हाँ वंदना, hello, hello, नेटवर्क चला गया. आप सेल फोन से कर लो. कर दिया ना. ओके ओके ओके. लेट मी हेलो बोल दो. वंदना दिसली लसाम. दिसली. Welcome back, Vandana.
Yeah, sorry.
No problem. Please continue. Relax and please continue.
Yeah. So Zahira Habibullah Sheikh, who was a complainant in this matter, she filed a transfer petition for transfer of the criminal case which was going on in state of Gujarat to the state of Maharashtra, alleging that there was no credibility of the witnesses which were recorded before the trial court, as the public prosecutor is not the conduct of public prosecutor is doubtful, and she has the apprehension that nobody will cooperate, or she will be investigating agency also will not cooperate to her. So Honorable Supreme Court, while going through all the records of the documents placed before them, they observed that after going through the ample evidence which demonstrating the glaringly demonstrating the or the which are sorry evidence which were brought on record were demonstrating that there are evidence which shows that there is investigation or the trial will not be conducted as per law, and thereby to do the complete justice, and not only to do the justice but to show that justice has been done, the case was transferred from state of Gujarat to the state of Maharashtra. Then the next power for transferring of cases under Article 139A of the Constitution of India, whereby there are several cases which are pending before several courts in all over India, and which used to be transferred for the sake of convenience of the parties at one place. If you must remember that Bhopal tragedy case or Union Carbide Corporation versus Union of India, which was pending before the District Court Bhopal, it was transferred to by the Supreme Court to itself to decide the quantum of compensation to the victims, as well as to decide what liability has to be imposed. Then, if you are aware of this Muhammad Ismail Faruqi, Union of India, Muhammad Ismail Faruqi, which was relating to Ram Janambhoomi case, there was the government formed a Land Acquisition Act for Ram Janambhoomi. This ordinance was challenged before the High Court of the Allahabad, which was pending over there. So during pendency of this case, a presidential reference was made to the Honorable Supreme Court. So while pendency of that presidential reference, Honorable Supreme Court transferred that matter, that writ petition which was pending before the Honorable High Court of Allahabad, whereby that act was challenged, to itself. But as presidential reference was referred back, that I will tell you at the time when jurisdiction under reference under Article 143 will come. So next is one more matter is DDA versus Skipper Constructions, which Skipper Constructions Limited, which was a builder, and they duped so many investors, and the cases were filed against them in all over India. So the Supreme Court transferred called all those cases to itself, and to decide the quantum. Now comes the next part of regional jurisdiction, which comes is the references under Article 143(1), which I just discussed. This reference number 1 is of 1993, which I have told you that Ismail Muhammad Faruqi, which was sent by the government for taking opinion of the Supreme Court on some law which they dealt is that legal opinion of Supreme Court is very much required. It is pertinent to mention here that the government is not bound by the advice given by the Supreme Court of India. So they can ask for the advice, but they are not bound whatever Supreme Court will advise them. The next is, reference is Kaveri Water Tribunal, whereby the ordinance relating to the validity of ordinance was challenged. Decision of whereby it was observed by Honorable Supreme Court that any decision given by Supreme Court on any question of law will be binding on all the subordinate courts and tribunals. In 2012 also, this is reference number 1 by 2012, which relates to the natural resources allocation case. Against the reference was given. And under procedure, you are supposed to know that references can be filed under this 143 as well as 307, Article 317 and sub-article 1. Article 317 is relating to the vacation or we say that when any public commission service officer is required to be terminated, services of any public service commission is required to be terminated. This was first time utilized, or in the matter of members of Punjab Vidhan Sabha, whereby the member of Punjab Vidhan Sabha misbehaved with the chairman of that Vidhan Sabha, and he was terminated from the services. Then election petitions also comes under original jurisdiction, whereby presidential elections are only challenged before the Honorable Supreme Court. Then under section 11 of the Arbitration and Conciliation Act, the Chief Justice of India has the power to appoint an arbitrator in a dispute which pertains to the international contracts or relating to international agreements. Then the next one is the contempt jurisdiction. As 2 or 3 days before, you must have seen that Honorable Supreme Court has invoked jurisdiction against Mr. Prashant Bhushan for contempt, for its own contempt. So this is also original jurisdiction. So these are relating to the original jurisdiction of the Supreme Court. Now appellate jurisdiction, wherein the civil appeals and criminal appeals are used to be filed. Civil and criminal appeals are filed under Article 134A, whereby certificate is issued by the Honorable High Court. If a question is relating to the interpretation of the Constitution, then Honorable High Court issues a certificate that this is certified by that question is required to be decided by the Honorable Supreme Court. If the certificate is related to the interpretation of the Constitution of India, in that case, the case will go to judges. The case is required to be filed within 60 days from the day when certificate is issued by the Honorable High Court. This certificate is again, civil cases can be filed under Article 132(1), then 133(1)(a) and 133(1). If appeal is filed under Article 132(1), then the case involves substantial question of law interpretation of the Constitution of India, and where only substantial question of law of public importance is involved, then appeal is used to be filed under Article 133(1)(a) and 133(1)(b). This is the civil procedure, in civil cases. Opinion of High Court is also required, that question is required to be decided by the Honorable Supreme Court, and the certificate must not be issued by a single judge bench. It must be, because the Honorable Supreme Court deprecates the practice of issuing certificate by a single judge. And as per, I will give you some judgments also in this. You can note down that in R.D. Agarwala versus Union of India, certificate by single judge was not appreciated by Honorable Supreme Court. So these are the judgments you will have to mention at the time of writing that, while writing a paper. So you can go through 4 or 5 judgments are sufficient to mention, so that it will be find out that you are aware of the procedure. Then in ITC Limited versus Presiding Officer Labor Code Bihar, wherein it was stated that once the certificate is granted and the appeal is filed in the Supreme Court, then it is open to the appellant to raise all sorts of grounds. One appeal which is filed under Article 136, where its leave is granted, that this appeal, while the appeal filed under Article 133(1)(a) will have wider scope than the appeal which has been filed under Article 136, or after which has been allowed in a special petition. In that, now the appeal must states that there is question of law. That question of law is a substantial question of law, and interpretation of the constitution is required, and it relates to the general public importance. Now, in criminal cases, criminal appeals are used to be filed under Article 134(1)(a) and 134(1)(b) as a matter of right, whereby Honorable High Court converts an acquittal into conviction and impose and sentence death sentence. First case. And second one is when Honorable High Court calls the case from district court to itself and sentences the accused to death sentence. The third is when under Supreme Court enlargement of jurisdiction, whereby if a person is sentenced to life imprisonment or sentence of more than 10 years, in that case they can file the appeal before Honorable Supreme Court as a matter of right. Now, under Article 134(1)(c) and 132(1), again, if there is any substantial question of law relating to the interpretation of the Supreme Court, relating to the Constitution of India, and any question of law which is substantial and is of public importance, that can be filed. The appeal which are used to be filed as of right, it is required to be filed within 30 days from the passing of the judgment, and the other whereby Honorable High Court certifies that a question involves substantial question of law or interpretation of the Constitution, that is required to be filed within 60 days. Then next come, which is on which the practice of the Supreme Court advocates are based, is Article 136, whereby 98% cases in the Supreme Court are used to be filed only under Article 136. So Article 136 is a discretionary power of the Honorable Supreme Court. They, as per the Supreme Court, this power is to be used on on the grounds in which there is a very much requirement, or showing that there is interference of the Supreme Court is required based on the facts or questions of law raised therein. In Pritam Singh versus State, the scope of Article 136 was first time discussed by the Honorable Supreme Court. So I would advise you all that these cases you can find out on Google, and you must try to go through these judgments, because these are having very relevant judgments, and which can enlighten all of us. So the next one was the next case is Dhakeshwari Cotton Mills Limited versus Commercial Income Tax, whereby it was held that this power under Article 136 will only be used as to advance the cause of justice. Then there are so many other matters whereby it has been held that the parties should approach to the court with clean hands and with proper facts. They should not conceal anything. If later on it is found by Honorable Supreme Court that any party has approached the Supreme Court under any of the provision, not only under Article 136, that they have not disclosed the proper facts, or on their whims and fancies they have tried to disclose the facts, then the Supreme Court deals with in these cases with sternly. Then there is a doctrine of, we can say, and now one question arises that once specially petition under Article 136 is dismissed, can a person come again to the Supreme Court on same question under Article 32 and file a writ petition? So now there also it depends on the case to case. In one case, in habeas corpus petition, if a petition under Article 136 has been filed and that has been dismissed, not on merits, but on in limine. In that case, if one person come and files a habeas corpus petition under Article 32, in that case, that has been dealt by Supreme Court, and in which also been passed, whereby writ petition was allowed. Uh, although special leave petition was dismissed. So in many of the cases, if a special leave petition has been dismissed under Article 136 and in limine, not on merits, in that case it is open to the petitioner to file a review petition before the High Court also. But if a special leave petition has been decided on merits and with a detailed order while mentioning that we have gone through all the facts, in that case they cannot approach to the High Court and file and should not file any review petition. Now, the appeals which are filed under special acts before the Honorable Supreme Court. These are Advocates Act, then Consumer Protection Act, then now is this company law and by the order passed by National Company Law Appellate Tribunal, by Customs under Customs Act under Section 130E, and under Section this is Customs Act. For the Excise Act is now repealed. So previously there was provision to file appeal before Supreme Court under Excise Act also, but now it has been repealed by GST. So these are the jurisdiction. Then comes review and curative jurisdiction. In review petition, review is a review can be filed against a order which has been rejected, where there is a they are showing that they are demonstrating any mistake on the face, error apparent on the record. In one case, which is Kameshwar Prasad versus Union of India, this is very interesting case whereby after dismissal of review petition and interim application was filed, stating that in similar facts of cases, another case has been allowed. On the basis of that, even after rejection of review petition, the Supreme Court recalled that order rejecting review petition, restored the special leave petition and granted same relief as was granted in some other matter. So you can note down and giving that. This is Kamlakar versus Union of India, 1999, 4 SCC 756. As per in Lily Thomas case versus Union of India, it was observed by Honorable Supreme Court that a review should not be an appeal under disguise, because it should be on limited facts which were raised on and limited grounds. You cannot come and again raise all the questions. In review petition, while filing review petition, a certificate by advocate on record is required to state that all these grounds were raised in the special leave petition. In Commissioner Sales Tax versus Fine Chemicals Limited, it was observed that when there is an error apparent on the face of record, a review should be allowed. And thereafter comes curative petitions. Curative petition was came in force by the judgment of Rupa Ashok Hurra versus Ashok Hurra, whereby again a writ petition was filed challenging the order passed by Honorable Supreme Court. In that case, it was held that although there should be some full stop to the proceedings, to the litigation, but when there is any fault on the part of court or any mistake has been occurred which was inadvertent, in that case there should be a remedy, and which remedy was given under the name of curative petition, whereby after dismissal of review, any person can file a curative petition, whereby certificate by advocate on record and certificate by senior advocate is must. Whereby in certificate which is used to be issued by advocate on record, it must be stated that review petition was dismissed by way of circulation, and the certificate which used to be issued, which is required to be issued by senior advocate, must state that he has satisfied himself that this case needs a consideration and is fit for filing curative petition. Then in curative petition, there are some interesting judgments also. One is Jakaris Lakada versus Union of India, whereby in review petition, the writ petition was filed after dismissal of special petition and review petition, wherein it was mentioned that accused was a juvenile at the time when he committed the offense. So this writ petition was converted into curative petition by saying, and which was allowed as this point that accused was juvenile at the time of offense was not noticed by the Honorable Supreme Court. Then one matter is Muhammad Arif versus Supreme Court of India, whereby petition again filed petition under Article 32, and he challenged the order 40 of the Supreme Court rules by submitting that a 30 minutes court hearing should be given to the accused, to the person who has been sentenced for death. This petition was also allowed. It was treated as a curative petition. Next is Yaqub Abdul Razak Memon versus Union of India, whereby he raised objection that curative petition is required to be considered by 3 senior most judges, where his curative petition was considered by 3 senior most judges, but not by those judges who passed the judgment. In that case, his curative petition was also allowed, and it was again considered. The curative petition is based on 3 principles of natural justice, that is audi alterum partem and par incuriam and ex debite justite. Therefore, whenever you are going to mention curative petition, you will have to mention these judgments also in practice and procedure. And one more case is Navneet Kaur versus State of National Capital Territory, whereby there was delay in considering the mercy petition. There was delay of 8 years in considering the mercy petition, and therefore her curative petition was allowed on this ground. As I've told you that we have to specifically aware that the grounds mentioned in the curative petition have been taken in review petition, and that it was dismissed by circulation, and certificate by senior advocate with regard to fulfillment of the conditions which are mentioned in the Supreme Court rules are also required to be mentioned. These are the main jurisdiction of the Supreme Court as suggested you that you must buy Supreme Court rules and go through, because some parts which are mentioned therein as the single judges which they can take whatever matters they can take, or the judges in chamber what matters they will take. It has been described in detail, and it will be easy for you to remember all those things. So now I may say that I have missed somewhere which I know, but I would like to improve myself also, because it was my first session. And thank you to all of you for hearing me so patiently and carefully.
Thank you, Vandana. Thank you, Vandana. It was very pleasant to hear you and go through all the judgments. I think you must have covered more than 40 to 50 judgments, and in such a small space of time, it was very difficult. In fact, I revisited a few of the judgments from Minerva Mills to Shankari Prasad to Antule's case. So I know, being an AOR, how difficult it was in our time. And I'm thankful to you. Because of you, I could revisit it, and with me, all the participants. And participant, this subject is very exhaustive, and Vandana is in agreement with me कि आज सब कुछ पूरा नहीं हो पाया है, but it's very exhaustive subject. We can cover the subject in next session whenever in the future, and but the purpose is to take few parts of the, because AOR exam का जो मैंने बोला था कि the जो पूरा जो syllabus है, everything under the sky is the like IAS का जो होता है, everything under the sun is the syllabus. In Supreme Court from आपको प्रीतम का फर्स्ट SLP से लेके अभी तक का सुशांत सिंह का राजपूत का भी केस मालूम होना चाहिए. It's completely regular update. So we'll continue on the next Thursday on another subject of the, I think paper 2 will take up. I'll discuss with Vandana ji probably, and we'll get meet you again. And thank you everybody for attending the session and hearing us patiently. Thank you everybody. I will ask everybody to leave the meeting. Thanks a lot. Have a pleasant evening.